My name is HEAH Sheng and this is my video presentation. The distinction between monist and dualist legal system significantly affects how international agreements like climate change treaties are incorporated into domestic law and how well countries meet their obligations. While doing so, various legal and practical challenges may arise. Domestic law governs the domestic aspects of government and deals with issues between individuals and between individuals and the administrative apparatus, where international law emphasizes on the relations between states. The general rule is that the provisions of a state's municipal law cannot be used as a justification for violating international law. The reason is clear, as under any other circumstance, the straightforward approach of domestic legislation would allow international law to be circumvented. According to Article 27 of the Vienna Convention on the Law of Treaties, a party is not allowed to invoke the provisions of its internal law as reason for failure of performance of a treaty. This rule is without prejudice to Article 46. Article 46 provides that a state cannot claim that its consent to be bound by a treaty is nullified because it violated a provision of its internal law pertaining to its authority to conclude treaties, unless the violation was manifest and involves a fundamentally important rule of its internal law. A violation is considered manifest if a breach will be objectively obvious to a state acting in good faith and conformity with standard procedure. It was held in the case of Alabama claims arbitration that the essence of British legislation necessary to prevent the construction of or departure of a vessel could not be brought forward as a defense, which resulted in Britain having to pay damages. A state is not allowed to plead before an international court that its domestic law authorizes it to do something that can amount to an intentionally unlawful act, as seen in Texaco against Libya. To put it simply, a state must fulfill whatever legally binding international commitment it has, regardless of whether its local law allows it or prohibits it. The state should alter local law if it's necessary to fulfill international commitments. The International Court emphasized the fundamental principle of international law that international law prevails over domestic law in the applicability of the obligation to arbitrate case. There are times when domestic law is crucial. Firstly, when there's the dispute between states and that can only be settled with reference to concepts defined in domestic law, as seen in the Notterbaum case. Other than that, it can serve as evidence of facts before an international tribunal, as seen in Anglo-Norwegian fisheries case. Thirdly, it can be seen as evidence of facts, evidence of state practice. Lastly, it can be seen as evidence of compliance with international obligation based on the case of certain German interests in Polish Upper Silesia. There are two main theories when it comes to the relationship between international law and domestic law, namely monism and dualism. Both monism and dualism provides perspective on how national and international law conflicts are settled and how international law operates within states. The monism theory supposes that international law and municipal law are simply two components of a single body of knowledge called law. Both sets of rules operate in the same sphere of influence and are concerned with the same subject matter. International law will prevail when a conflict arises. There are two distinct categories in which writers who adopt the monist approach will fall into. Those like Lauterpacht will uphold a strong ethical position with deep concern for human rights. Those like Kelsen will maintain a monist position on formalistic logical grounds. Lauterpacht, who was a member of the International Law Commission from 1952 to 1954 and a judge of the International Court of Justice from 1955 to 1960, upholds a strong ethical position with human rights. He sees the primary function of all law as concerned with the well-being of individuals. He was also a strong advocate of the supremacy of international law, as he believed that it was the best method of attaining human rights and the protection of individuals. On the other hand, Hans Kelsen, a legal and political philosopher, believed that the law lays down patterns of behavior which should be followed and provides that sanctions and punishments should be put in place for failure of compliance. This definition will apply to domestic law and international law. He is of the view that international law is much more basic than domestic law, which means it is more superior than domestic law. When it comes to the theory of dualism, it denies that international law and domestic law operate in the same sphere, despite having accepted the fact that it concerns the same subject matter. According to Heinrich Trappel, international law regulates the relations between states, while domestic law regulates the rights and obligations of individuals within states. Both legal systems will operate simultaneously in respect of the same rights and obligations. The theory asserts that the possibility of conflict may arise on the same subject matter that is being dealt with. It recognizes that each system will apply its own law unless the rule of the system says otherwise. Dualism is positivistic in nature, as it stresses the overwhelming importance of a state. In a state that practices a money system, the doctrine of incorporation is practiced. Under this doctrine, a rule of international law will automatically become part of municipal law without the need for express adoption. It is generally automatic unless a clear provision of domestic law precludes the use of international law by the domestic court. The best known exponent of this theory can be seen in Blackstone. On the other hand, the transformation doctrine, which is applied in a dualist state, states that the rules of international law do not become part of municipal law until they have been expressly adopted by the state. The transformation will occur with the appropriate constitutional machinery, such as an act of parliament. The doctrine grew from the procedure where international agreements are rendered operative in domestic law through ratification by the sovereign. I'll now share on how international law is applied in the UK, which is a dualist state. The doctrine of incorporation is the British approach towards customary international law as seen in the case of Bouvot against Bobbitt. Chief Justice Cockburn was in the view that even if there is broad international consensus or agreement, it will not be sufficient to allow domestic courts to automatically apply international law in the country. In order for any international law to be applied in the UK, all its treaties had to be laid down before both houses that was either signed or intended to accede. Text of any agreement that requires ratification, acceptance, approval, or accession has to be laid down before Parliament at least 21 sitting days before any further action. I'll now move on to the challenges that each system occurs. The first challenge in legal compliance on the money system is the inadequate domestic law enforcement system. Although international agreements are capable of being directly implemented into the domestic legal system, the necessary measures may not be enforced domestically due to a lack of political will. A climate change issue can be tough to tackle as it's a long-term issue where significant amendments to local law will need to take place. The local government may not be inclined to change the law since it may involve high costs and making changes to existing policies which may seem troublesome to them. The next challenge that arises in a money system when trying to harmonize with international regulations is that some regulations may contradict with each other. A particular nation may already have laws in place to regulate their emissions. The terms of the multilateral agreement may conflict with existing domestic laws, which can cause confusion and uncertainty. For instance, a nation that practices a money system may promote industries which have high emission levels, while the international agreement seeks to reduce the emission levels. Thus, it can cause ambiguity to those working in the aforementioned industry since the laws are in contrast to each other. Moving on to the dualist system, the first issue is the slow process of passing the enabling legislation in the country for the agreement to be incorporated into national law after the multilateral agreement has been approved. Although a country may have signed and ratified an international agreement, it takes quite a long time for the agreement to come into force. This could be due to Parliament having to deal with large numbers of legislation. Thus, it could even take months or even years for it to actually come into force. This could be due to Parliament having to deal with large number of legislation. As a result of the delay, a nation will not be able to comply with the emission reduction targets that have been set. Not only is this detrimental to the environment, it could also jeopardize the relationship between different countries because of its failure to comply with the reduced emission. Fines and sanctions may also be imposed, which can leave a significant economic impact on a particular nation. The next issue is that legislators and other political players may decline to enable the legislation necessary to execute the international agreement. This is due to the fact that they may feel that it goes against their political agenda or the interests of the nation. They may also be under the pressure of big corporations that they are directly impacted by the agreement to behave in such a manner as the agreement may have a significant impact on those corporations. For instance, fuel and energy companies may resist the legislation because they may have to invest in new technology and infrastructure to reduce their emissions. which can be costly and result in a loss of profit. Under the influence of these corporations, government officials may then seek to prolong the timing of the legislation is passed or weaken parts of the legislation for the benefits of the corporations. Some recommendations will now be provided as to how consistent adherence across legal systems can be improved. In order for international obligations to be upheld, nations under both the dualist and money system must tighten their enforcement mechanism to ensure strict compliance to the emission levels that have been set. This can be done so by having regulatory bodies that monitor emission levels of organizations and by imposing fines on those who fail to comply. The next recommendation is that the national government should work to ensure that their policies are in line with the goals of the climate agreements. They can achieve this by conducting reviews on governmental policies that are being implemented at the moment and make the necessary amendments when necessary to ensure that it's consistent and does not conflict with the target that has been set under the climate agreement. For instance, the government could reduce fuel subsidies in an effort to reduce carbon emissions. They could also establish clear and measurable climate targets which will show that they are committed to adhering to the standards set under the agreement. The third recommendation I have is that the government authorities should have stronger political will when enforcing the agreement. For the international climate agreement to be carried out successfully in both systems, the government authority needs to possess a strong political will. The government should not prioritize their own interests and not give in to the pressure of big corporations. Instead, they should work together with these big corporations to reduce their emissions and make themselves more sustainable to meet the target set under the agreement. All in all, both legal systems have their own set of disadvantages and advantages. The level of compliance towards the emission targets will also vary depending on the legal system and political state of that particular nation. Thus, it's crucial that those in charge take responsibility to bring into force the necessary legislation or implement the necessary measures to meet the target of the agreement. Thank you.